Why prosecutors drop cases and how to make yours next.
Hi, my name is Christy Fram and I'm an attorney here at the Nieves Law Firm. And today I'm going to be discussing with you why a district attorney would not file charges against you. Now, there are a multitude of reasons why a district attorney will not choose to file charges. So generally how the process works is the police will have arrested someone for allegedly committing a crime and would recommend to the district attorney what charges the district attorney should pick up. The police report is sent over to the DA's office, the DA receives it, and then a DA is assigned to review the matter and determine whether they want to file charges or reject charges. And what a district attorney is looking for when a matter is under review is whether there is enough evidence to prove beyond a reasonable doubt that somebody committed the crime that they're being accused of or that they were arrested for. Sometimes there's not enough evidence, or a key witness is not cooperating with the district attorney, and so they won't be able to prove their case. So those are examples of why a district attorney may not pursue charges on a matter. A district attorney may believe that a particular matter is not serious enough to charge, and there are several other more serious matters that are pending review and pending a decision on whether to charge, and a district attorney may choose to pursue those as priority. Sometimes, if there's a misdemeanor that is under review, the district attorney generally has 1 year to file charges or determine if they want to file charges. Once it is past the 1 year, that is what is called past the statute of limitations. The district attorney has 1 year. They are limited to that 1 year. Another reason why a district attorney may reject charges is because there are too many procedural errors that were done in the investigation. For example, a police officer violated several constitutional rights to arrest this person or after the arrest of the person. And so those are things that a district attorney is going to take into consideration, because if they do choose to file charges on a matter that has several constitutional violations that happened in the procedural aspect of the investigation, then a defense attorney is going to be filing motions to suppress a lot of the evidence. And if the evidence is successfully suppressed, which it will be if there are violations of the individual that was arrested's constitutional rights, they're not going to have a case. And so it's a waste of the resources, it's a waste of time, it's stressful, waste of energy, and unnecessary to bring forth a case that is that weak, that has so many violations. I have a specific example to give you. It's another reason why a district attorney may reject charges. So I had a situation where my client was being accused of domestic violence by his wife. His wife called the police on him one day. He got arrested, and the matter had been under review for some time. And while the matter was still pending, the wife filed a domestic violence restraining order against my client. And this matter did go to hearing. And in a domestic violence restraining order matter, the standard of proof is by preponderance of the evidence, meaning that she had to show that it was more likely than not that my client subjected her to abuse. She lost. She could not prove by preponderance of the evidence that my client subjected her to any abuse. And that is a very low burden. So when a crime is being charged, the district attorney has a higher burden to meet. So it goes preponderance of the evidence, clear and convincing evidence, beyond a reasonable doubt. Prosecution's up here. Prosecution needs to prove beyond a reasonable doubt that this individual committed the crime against the other individual. And so since my client's wife couldn't even prove by preponderance of the evidence that he subjected her to domestic violence, the prosecution is not going to be able to prove beyond a reasonable doubt that my client committed domestic violence against her. So that's another very specific example. Every situation is different. However, it just kind of puts things into perspective. Sometimes also Situations like that help with negotiations with the reviewing DA. When the DA is still looking at the police report and reviewing the evidence and what witnesses are available and what the case is looking like on their end, that is where a defense attorney can step in and negotiate with the DA in the review process and kind of show like, hey, look, a domestic violence restraining order was filed and denied against my client, which is the person in question for the crime. And the standard is so low and it couldn't even be met then. And so motivating factors for the DA to kind of just realize that this is not a case that you're going to be able to prove. That is another example. So if you are facing potential criminal charges, it is helpful to have an attorney even before you're charged, even if you're never going to be charged. You'll never know that. You'll never know if you are being if you're being accused of a misdemeanor. The district attorney generally has 1 year to determine whether they want to file charges or not. For felonies, it's 3 years, and there are some exceptions. There are some crimes that don't have a statute of limitations. But nonetheless, if you are someone that was arrested or you are worried that there are potential criminal charges that may be brought against you but have not been brought against you yet, it is a good idea to hire an attorney to monitor your case even before the DA chooses to charge, because there are different things that a defense attorney can do to try and negotiate with the reviewing DA to drop the charges, or to negotiate with the reviewing DA to either reject the charges or reconsider their decision before putting the matter on calendar and moving forward with active criminal proceedings. So if you are someone who is worried about potential criminal charges against you, or you are aware that you're on the district attorney's radar in some shape, way, or form for if there's a police report that was filed against you, if you were arrested at some point and cited, released, it is wise to hire an attorney to monitor your matter even before charges are filed.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.